Sure, abuti honestly.
Ms. Mkabayi from Mkabayi Attorneys, and I confirm that I appear on behalf of Mr. Van Rijn in this matter. I further confirm that these are judice instructions. My Lord, yesterday, or before I go there, my Lord, when the news about Joshlin's disappearance broke, the whole country came to a standstill. Not only South Africa, my Lord, even the global village. But the unfortunate part in this matter is that the investigation didn't do justice in this matter. Mostly, my Lord, poor investigations, they have a tendency of leading to unlawful arrest resulting to malicious prosecution. In this matter, the state has a duty, it is an onus to discharge its case beyond reasonable doubt. I have listened to my learned colleague yesterday from early as 8:30, including 1 o'clock. She didn't come closer to prove their case beyond reasonable doubt. There's no evidence before this court that my client, Mr. Van Rijn, did unlawfully and intentionally deprive Joshlin of her freedom of movement. There is no evidence before this court that my client, Mr. Van Rijn, delivered Joshlin to anyone for any amount. My learned colleagues were noticing that they failed to discharge the onus. They are pleading with this court to convict Mr. Van Rijn on speculation. Speculation drawn from the evidence of a 204. My Lord, I would like to pause and look at the person of this 204 before even she was arrested. She testified before this court that she was taken to Langaban. While in Langaban, they were taken to an open space where they were assaulted severely. And while they were assaulted, they were asked about the disappearance of Joshlin. She testified that the people who were assaulting them, it was herself and Ayanda. Ayanda is known in this court as her partner. They were assaulted by people who were covering themselves with barricade. They were assaulted, they were taken back to Langaban. From Langaban, they were taken to police station. At the police station, her partner was released, but after some time, she was arrested. She was arrested on the 13th of March, 2024. We've got this 204 after being, or during the assault or the torture. She doesn't confess to the people who were torturing her. We've got this 204 who's arrested on the 13th of March. She's appearing in court. She doesn't confess. There's something I know about this offense. I've got information that can help the state. She's quiet. We've got March 2024, April 2024, June, May 2024, June, July, August, September, October 21st, 2024. The same person who was tortured 7 months before is saying now, I can confess. That and that alone is saying a lot about this 204. Let's bring her before court. Before she was brought before court. She was taken before Sergeant Sihobe for a statement. Sergeant Sihobe is such a polished police officer. She impressed me when she was administrating an oath to Laurentia Lombard. She told the court that I am fluent in Afrikaans. We spoke in Afrikaans. But I wrote my statement in English, but she understood everything. After I wrote my statement, I read it back to her. I asked her, do you understand? The answer was yes. She took an extra mile further by asking her, do you want to add anything? Do you want me to correct anything in your statement? The answer was no. After that, an oath was administered. She said, even though she was twitching her arms, but she could understand. While I was taking her statement, this is a testimony of Sergeant Sihobe, she made me to believe that what she was telling me is the truth. Now, when confronted under cross-examination, no, I was scared. Scared of what? Sergeant Sihobe is more or less of her age. Is young. I was scared. Maybe I had a relapse of drugs. So that's why I lied. What is surprising me worse, my Lord, is that she knew she was lying. But she continued. Like, that's not even a lie. She fooled an officer. That's the 204 we're having before this court. As if that was not enough. Now, she went to give a confession. She didn't stop. She's referring to the officer who was taking her confession as a woman with a gray hair. I suspect she looked older than Sihobe. She was supposed to respect that officer. These people are trained. These are the pride of our country, law enforcement officers. We've got a 204 for the second time who is lying before an officer. In court, her confession was amended by the state. Which value do we attach to that confession? With its lies from the owner, with its amendment by the prosecutor. As if that was not enough. Now she's appearing before Captain Lombard. She doesn't stop lying.
I'm with you.
When 204 statement was brought before this court, it didn't stand the test of cross-examination. There were many lies, contradictions, inconsistencies. Now, someone if we take the defense when she first appeared before Sergeant Sihobe that she was relapsing from drugs, was she even relapsing from drugs after 7 months on the 21st of October when she lied? Was she still relapsing when she lied before Captain Serious? No. I asked her, do you believe in God? Were you brought up in a godly family? He said, yes. My parents told me about God. I asked her, do you know the consequences of lying? She said, yes. She even said, even at school, my teachers told me about God. They told me about the consequences of lying. But she didn't stop lying. We cross-examined her, 3 of us. She lied to my learned colleague for Mr. Apollis. She lied to me. She lied to my learned colleague for Miss Kelly Smith. Now, surprisingly, the state is convincing the court. Now that I have failed to prove the elements of kidnapping, trafficking, please, let us convict the 3 on speculation. Wow. Where is that coming from? Speculation, we're drawing the inference from the evidence that was led by 204. Which 204? The one who lied uncontrollably. The one who fooled 3 police officers. Now, let's go to these speculations. When she was giving evidence, my learned colleague asked her a leading question. Who were present in the discussion? 204 has never mentioned anything about a discussion, but my learned colleague asked her, who were present in the meeting? I knew discussion. I knew that word discussion, where it was going to. I knew it was going to concoct the principle of common peoples. She mentioned 6 people who were present in the meeting. Another surprise, my lord. In that list of 6 people, she mentioned Joshlin, she mentioned Requeen. A follow-up question, very fast follow-up question was, where was Joshlin? Where was Requeen? Now is placing them in different places. Requeen was in his bedroom, Joshlin was playing outside. I noticed that discrepancy. I waited for my time for cross-examination. But unfortunately, there was a ruling that I cannot put questions on that piece of evidence. I knew that piece of evidence is going to take us to the principle of common peoples. My lord, I object strongly. The state is not going to come and say there was a discussion. The state is not going to come and say there was a plan. The state is not going to come and say, yes, discussion, meeting, or plan. The state has to unpack and break down the discussion. In the discussion or meeting or plan, what was my client's role? What were his ideas? What was his input? Who was the chairman of the meeting? Where are the minutes of the meeting? We're not going to allow a state to come and thumbsuck meeting plan without the basis. I will argue that. The meeting, the plan, the discussions are unfounded and they're baseless. And the state cannot cry common peoples without first proving the elements of this of the main charges beyond reasonable doubt. We're not going to have a common purpose. It's a common purpose for what? Common purpose to do what? My client didn't deliver Joshlin. They didn't prove that. They didn't prove the intent. They didn't prove unlawfulness. They cannot. Another issue. My learned colleague argues yesterday that there was an act Who acted? When? With who? When you traffic, you don't traffic alone. There's the other person. Where was this act? With who? Silent. Their conduct. Whose conduct? My client's conduct that day was his conduct even the other day previously. Did the state know how did my client conduct himself before the 19th? Which conduct are they referring to? My client on the 19th of February was selling the microwave. When did it become a crime in South Africa to sell a microwave? When did it become a crime in South Africa to visit your friend? I will argue that that was a common purpose to sell a microwave, not common purpose to kidnap or to traffic anyone. My learned colleague argued that Joshlin has been delivered, and she has been delivered for the purpose of exploitation for slavery. By who? Where? Who are the exploiters who are exploiting Joshlin? We want to know. In which place? She has to tell this court. She didn't. For 4 hours, 30 minutes, I was listening patiently for the state to prove its case beyond reasonable doubt. No compelling evidence before this court, no strong evidence before this court suggesting that my client committed an offense of trafficking in person, kidnapping, and all, any conspiracy. I will refer this court to those cases, the court said I cannot, there's no need for me to refer to them. Now the point I wanted to make, my Lord, is the point I wanted to make, this onus has not shifted. This onus is still upon the state. My client is not guilty to prove his innocence. He has no duty to do that. The duty is upon the state. The duty that they've run away from. They know why. Now coming to my client, on the 4th of March 2024. Where was my client on the 4th of March 2024? On the 4th of March 2024, my client was at Fredenberg Saldana hiking spot. He was with his cousin's boyfriend. He's hiking from Fredenberg to Saldana. It was in the afternoon. While he's hiking, he was taken by the police. They never told him, they never introduced themselves to them. We are the police officers. We are looking for you. We are looking for you because you are a suspect in this case. Arbitrarily, they infringed his right to human dignity. He has a right, constitutional right to be treated with dignity, a right to be treated with respect. That right applies to anyone. You are educated, you are not educated, you are rich, you are poor. It applies to every individual person. I will argue that Section 10 of our Constitution that gives my client rights to be treated with human dignity was infringed by the police who took him at the hiking spot. I will refer this court to the case of Mahlangu.
Which one? Is it one of the cases that you sent me?
My lord?
Is it one of the cases that you sent us?
Yes, my lord.
Mahlangu.
Is J.E. Mahlangu? IT Mailela?
It's not one of the cases that we've uploaded, but if you give me the name of the case, I'll find it quickly.
Can I show the just the front page? Maybe we'll quickly get it.
It's not one of the cases, but I'll quickly find it. Yes, it's the Constitutional Court case of Mahlangu versus the Minister of Police.
Yes, my lord.
2021 ZACC page 10. Yeah, what about it?
My lord, I would refer this court to paragraph 27 of the case.
Well, first tell me what was this case about in the Constitutional Court?
This case was about it covers two things. It was about the confession. I'm not going to concentrate on that. And it was about the infringement of Mr. Mahlangu's rights, my lord.
This was a case that dealt with the damages.
Yes, my lord, at the end, yes.
Following from
yes, my lord.
An unlawful arrest and detention.
Yes, my lord.
You want to take me to paragraph?
Paragraph 27, my lord.
Mm-hmm.
The unlawful deprivation of liberty with its accompanying infringement of the right to human dignity has always been regarded as a particularly grave wrong and a serious inroad into the freedom and rights of a person. There's a reference in that paragraph, my lord, to the case of Tandanani. I don't have that case of Tandanani.
Well, it's Tandani versus Minister of Law and Order, 1991, 1 SA 702 Eastern Cape.
In that footnote, yes, my lord.
And the other references is to Peterson versus Minister of Safety and Security in RF, which is a well-known appellate division case on delict. RF versus Minister van Polisie, 1977, 2 SA 900.
Thank you, my lord.
And there's a sub-reference to another decision of the old NPD, as it then was, in May versus Union Government.
Thank you, my lord.
Yes, we can go back there if you want to,
okay.
to paragraph 27.
Thank you, my lord. In Tandanani, the court said that sight must not be lost of the fact that the liberty of the individual is one of the fundamental rights of a person in a free society, which should be jealously guarded at all times. And there is duty on our courts to preserve this right against infringement. Unlawful arrest and detention constitute a serious inroad into the freedom and the rights of an individual. My Lord, the state didn't call this police who took my client from the hiking spot to come and testify. From there, he was taken to Jacobs Bay Beach, where he was further tortured. I will argue, my Lord, that additional to Section 10, a right to be treated with human dignity, his rights in Section 12, 1A, and in Section 12, 1D, and in Section 12, 1E, were also violated, my Lord. Section 12.1d, my Lord, is a right not to be tortured in any way my client, and at Jacobs Bay Beach, he was tortured in the following ways. And this piece of evidence remains undisputed. The police who tortured my client, they took him to sea border. They are known, but they were never called. I'm not going to repeat how he was tortured. The court is aware. The third right, it's not the third, the fourth right that was violated is 12.1e. Constitutional right not to be tortured or treated or punished in a cruel, inhuman, or degrading way. This started from Jacobs Bay Beach until sea border offices. I'm not going to repeat what took place in sea border offices. It is on record. But I would like to refer this court to the matter of Khoza.
Of?
Khoza, my Lord. Khoza Mpepu. It's known as Khoza judgment.
Also not one of those that you gave us. So give me the... Yes, it's not one of the lists that you gave us yesterday, but I have the case open, and Yes.
Thank you, my Lord. COSA is a matter where during COVID, our soldiers beat Mr. COSA. They tortured him. He died. They threw his liquor outside. Summarily, those are the facts of this matter. I would like to take this court to paragraph 8 of this matter of COSA, my Lord.
Now, before we go there, what was the case about? Because remember, if we need to find whether it's a ratio decidendi or whether it's obiter remarks made by the judge to determine how I deal with it. So this is the well-known case of where the gentleman went through a lot of trauma at the beginning of the lockdown.
Yes, my Lord.
So the relief that was sought in that case was declaratory relief. And it's set out in paragraph, the relief is quoted in paragraph 23 of the judgment. And I'm going down. Was this matter litigated further after this judgment?
I'm not sure, my Lord.
Have you checked? I'm going to the ultimate order that was granted. The order that was granted was a declaration in terms of the Disaster Management Act. And for people to report the abuse, and I'm putting it widely, to certain institutions. So the primary concern that the court had to deal with was the validity and constitutionality and enforcement of those, looking at the judgment itself. In paragraph 84 of the judgment, the court says, submission was that there are a number of reasons why this declaratory order should be granted. And he underlines, to vindicate the rule of law and the conduct of the security forces threatens or has in fact violated the Bill of Rights. So for what purpose is this matter, am I being referred to this judgment? And then we can go to paragraph 8.
Okay. For the following reasons, my Lord. Mr. Mahlangu was tortured by the law enforcement officers. SANDF members. When this matter is argued by the judge is also making reference, is not confining himself to the SANDF only, is making reference to all the law enforcement officers. It's making reference to the SAPS. It's making reference to the SAPS Act, the manner in which the police officers has to conduct themselves.
No, I'm not saying it's not an appropriate judgment, simply because I didn't have the opportunity to study it before now. So when I go back this afternoon, I want to go have a read of the judgment, but I want to know what must I look for. So you've referred me to paragraph 8.
Paragraph.
And that's just stating the principle.
Paragraph 55, paragraph 57, and paragraph 55, my lord.
8, 55, 57.
Paragraph 57 and 58, and paragraph 61.
Good, I will go and have a look at it.
Thanks, my lord.
As we go along, Ms. Nkabai, what I do is I open up the cases, but I leave it on my system. So when I switch on my laptop this afternoon at home, all of them will still be here. So I can just...
Thank you, my lord.
I can just click on them.
All right.
I don't close it when I leave here this afternoon. I'm not going to switch off my laptop.
Thank you, my lord.
I'm just going to leave it open.
Okay.
Let it go to sleep, and when I get home, I'll switch it on and it will be here.
Thank you, my lord. When the state witnesses who were present at sea border, when they were asked about the torture, Brigadier Anana denied knowledge of the torture. Captain Lombard denied the knowledge of the torture. Sergeant Fortin denied the knowledge of the torture. And Sergeant Johnson, they all denied the knowledge of the torture. Now I would like to refer this court It might not be relevant, but the principle is the same, my lord. It is an inquest that was reopened in the High Court, Western Cape Division, Cape Town.
It's a well-known inquest of the late Imam Abdullah Harun.
That's correct, my lord.
Yes, I have the ruling open in front of me. It's one of the matters he wanted me to look at. That I was given a list yesterday, and I looked at it.
Thank you, my lord.
But it's also a well-known incident. In the history of the struggle in South Africa, of an incident that happened in September 1969.
Thank you, my lord. In conclusion, the state has two versions before this court. Joshlin being taken to the White Polo, Joshlin being taken to Makalima. In the White Polo, we're told that he went with a woman that is described as a ngoma wearing a red cloth or a red dress. In Makalima's place, we're told that there was a man with a red shirt. Division of the proceeds in 204 statement was going to be done by one of the co-accused. In the story of the T-shirt, there was a story of 5,000. But this story of 5,000, my lord, is not corroborated by anyone. Either the story of the T-shirt. These are the versions that are before this court. I humbly submit before this court that the state has failed dismally to prove its case beyond reasonable doubt, and that the defense has a right to choose if they want to remain silent. They won't ask permission from the state for that right. I'm referring this to the case that was referred by the state of Prosecute. I request my client not to be convicted on these charges. As the court pleases, my lord.
Thank you, Ms. Nkabai.
Sure, I would honestly.